Welcome back. You're now watching the political segment on the weekend show. My name is Andy Madaki. The Presidential Elections Petitions Tribunal has set Monday the 8th of May for the hearing of the 2023 presidential elections. And so Monday would be the pre-hearing session, after which a timetable will be set for the process. Why has it taken this long for it to start, especially with it being this close to the inauguration? What's the implication of this? Can the inauguration go on while the Petitions Tribunal is still sitting? These are the questions Nigerians have been asking, and so today we would like to discuss and understand the election petitions process and how it affects Nigeria politics and the next coming days. And joining us, we have Matt Obono, who is the managing partner at TAP Legal Service, to shed more light on this. Welcome back to the Weekend Show, Matt.
Thank you so much for having me, Andy.
Thank you. So the last couple of months have been all about elections and conversations around it, and so we currently are aware that the PDP and the Labour Party are contesting the victory of Bola Ahmed Tinubu as the incoming president, and so the hearings for the tribunal will start on Monday the 8th. We want to understand what this process is about and the implication of this.
So basically, the Electoral Act provides that you have to file your petition after election has been concluded, within 21 days after election has been concluded. And there are quite a lot of other things that are involved in that in terms of the process. So for you to file an election, at the tribunal, you have to also have a locus standi. And who are those people who have locus? Either you're a political member of a political party, or you're the candidate himself that ran for the elections, and then INEC. So within these three prisms, you also have grounds for which you can file, to the tribunal, and they are not just so easy. So you first of all have to be able to prove that the candidate who won the election was not qualified at the time of the election to run. You also have to prove that the candidate won the election through corrupt processes, and then number three, that the candidate didn't meet the constitutional requirement for winning that election. So these things need evidential proofs, to provide to the courts. You need to have a time frame to gather this evidence and also put your issues together to present, and that's within 21 days. Now, then you also have 180 days for, the tribunal, which is the Court of Appeal in terms of the presidential elections, to determine whether or not the candidate won the election or the petitioner won the elections. Now, that is where the big problem is. And for me, it is the problem of when elections were conducted. So if we're going to be having this back and forth all the time, where a candidate will then be pressed, or an elected president, the president-elect will then be pressed to be sworn in on May 29, why can't we shift our elections forward, or backward rather, and say, okay, we have to conduct our elections 1 year before May 29, for example, if we have to maintain that May 29 as sacrosanct. Because one of the conversations that has been going on right now has been whether or not May 29 is sacrosanct, whether it is actually a constitutional provision for handing over to the next elected president or governor, as the case may be, for swearing in. So we've got to then stretch that and say, okay, if the time is too short for us to do this, because one of the major things people are afraid of is the power of incumbency, for example. The power that, okay, if I become a president, and then I have a case at the tribunal, I can influence the process, because we still don't have judicial independence. There's a state capture of judiciary currently, and so people fear that that will definitely influence the outcome at the tribunal and even at the Supreme Court. So, can we then have the elections moved back to take these things into consideration, so that we have a clean and clear electoral process, in Nigeria? So that is a major issue. And for me, it's not whether or not May 29 holds, it's whether or not INEC, in its next guideline timetable to conduct an election, will take these things into consideration.
So, and that's something which I wanted to learn about. So is this a provision which can be amended in the Electoral Act? So is this something that INEC can do in their guidelines, or is this the responsibility of the National Assembly to avert such crisis? Because I understand in 2003, President Buhari also raised this concern, saying the incoming president shouldn't be sworn in until the case had been decided. So is this a constitutional matter wherein the amendment should be done by the National Assembly, or can this be done with INEC's guidelines?
So it can actually be looked into from the Electoral Act, and then because obviously the Electoral Act also provides the guideline, I mean the framework for which INEC then makes its guidelines. So it can actually be from the National Assembly, because the fear basically is just too much that, okay, a president who is already sworn in can do and undo using his powers to influence everything. So I think it has to start with the National Assembly in terms of amending the Electoral Act for the time when elections can be conducted, because this happened before. And then INEC, the Electoral Act, I can't remember what section that was, it was then stipulated that elections must be held 3 months before swearing in. So we can then understand the peculiarities of our situation right now and say, okay, as our democracy improves and grows, we can then extend it much more further, to take into consideration the preparedness of INEC and the preparedness of the judicial processes in terms of delivering the final verdict as to who emerges and who wins the elections.
Okay, so you mentioned 3 criteria, and one is if the candidates are qualified to run, and the second bit, which is an interesting area, is if the election was won in a corrupt or fraudulent process. Now, so this shines the light on INEC. A lot of people have stressed that INEC promised to do live transmission of the votes, and we didn't get that. The IRF platform, even today, 69 days after the election, not all the results have been uploaded. So in a case where the first criteria, where the candidates have to be qualified, say they are accurately and adequately qualified, and in the third point where they meet the constitutional requirement, let's say the bone of contention is the process where INEC is the culprit in this case. Will that be grounds for nullifying an election? And if that happens, what would be the way forward?
Okay, so it depends on, I probably do not, because it's going to be sub judice,
Yes.
not want to delve so much into what, because these are issues that have been raised in both the Labour Party's petition and the PDP petition. However, and it's before the courts. However, if INEC provides and provides a guideline that this is the guideline we are going to follow, and then along the line decides to not follow that guideline, then it's actually a ground for the nullification of that elections, and for the courts to say, okay, we need to have a fresh elections where these guidelines will be followed, because rules are meant to be followed. Yeah. And one of the biggest issues for me is actually the fact that the burden of proof is on those who lost the election, for example, the petitioner. If we need a whole lot of overhauling of the entire electoral process, right? Now, the burden of proof shouldn't be, you can't conduct an election and then say that the election is free and fair. And it will be me, the onus would then be on me to say, oh, the election wasn't free and fair. No, it should be the other way around. If the burden of proof moves from the candidate who is petitioning to INEC as an institution, INEC will learn to do the right thing, because they wouldn't want to come to court to say, we didn't meet all these criteria, for this election to be considered free and fair. INEC would then be put on a hot seat to ensure that everything is done, because the standard of proof will be a bit higher, on them. So I think that if we are going to amend and do things differently in Nigeria, we need to, first of all, overhaul the INEC and see that the INEC itself begins to, first of all, conduct elections 1 year before May 29, so that it gives room for the 180 days at the Election Petition Tribunal, which is the Court of Appeal, and then the Supreme Court, which also has to do with 60 days, and also gives time for petitioners to put their ideas, their thoughts, their evidence together for justice to actually be seen to be done.
Okay, I know you just mentioned 60 days because that's what I wanted to ask. So with the Presidential Election Petition Tribunal now, once they start sitting, do they have to reach a decision before the 29th of May constitutionally? And if yes, how long does the Supreme Court needs to have before they make their own ruling on the same matter, if appealed?
Okay, so the interesting thing that the learned silk, Ulisagbakuba, actually said was that, and that is actually the truth, you don't have to exhaust the 180 days. And the issues are not rocket science. So for example, I'll merge both issues of the Labour Party and PDP together and say one of it was that the candidate wasn't qualified. You don't need 100 days, you don't need 1 week to determine whether the president-elect was qualified or not. You just need to sit down. Okay, what are the criteria for qualifications? A, did he meet it? B, did he meet it? You tick that. And within 1 hour, you've decided that. Okay, the other question is 25% from the Labour, from the PDP. Did the candidate, the and in the Constitution, the whole conjunctive statement or not? Does this mean conjunction or not? If it does, you tick that. Within 2 minutes or 1 hour, the justices of the Supreme Court or the panel of the tribunal can actually decide this within 24 hours or less. So it's not, we do not have to exhaust all the provisions of the 180 days. Maybe you could say, okay, if there are forensic evidence, proves here and there to do, you can then decide, but 1 ground is enough to nullify an election, or 1 ground is enough to uphold the election of the president-elect or thereabout. And then the third, which is supposed to be another outcome of this whole petition, will be to either say you declare one of the other contenders winner or not. So it's a very simple matter. We do not have to exhaust the 180 days. We don't have to spend 6 months, 60 days at the Supreme Court for us to know whether or not we have a precedent in May 29 or not.
So a new addition, which I think one of the parties want begged the courts to amend their petition, was on the grounds of perjury. Is perjury a ground for disqualification of a candidate pre- and post-election?
So perjury is a criminal offense. Once you've perjured, you have 14 years to face in prison. And once you've been convicted, you can't stand an election. So you lied on oath, essentially. And so if the president-elect is considered to have perjured, then he can't be a president. He can't be sworn in, because he hasn't even upheld the law that he's going to swear to uphold the Constitution of the Federal Republic of Nigeria. Okay,
talking about statutes of limitation, there are some crimes where after 10 years, all sins are washed away. So for instance, I know in most countries, let's say you're deported from a country, it's for about 10 years, and so you can apply for a visa for about 10 years later, you can. Now, one of the issues which have come up is a court case against the president-elect, but this was in the 90s. Is there a statute of limitation which says after XYZ number of years, this doesn't have to come up anymore?
So in criminal cases, there is no statute of limitation. There is no statute of limitation at all. Once you have a criminal case and it hasn't been, so what happened in this issue is that the case was in America and it hasn't been brought to Nigeria for, to be tried and all that. So, and if you've been convicted abroad, it's deemed to mean that you're an ex-convict, again, I'm not going to go too deep into all those issues. But the question, therefore, is where statute of limitation applies is where you have civil offenses. So those offenses could be statute barred after a period of time, but not in criminal instances.
I think that's a brilliant place to leave it. Matt, thank you so much for shedding insight and light on this case. We will be following up the process closely, and we'll definitely be bringing you back to hear your thoughts as it goes on. And to our viewers at home, thank you for joining us. We have a live broadcast after this show. You can watch this show on YouTube, Weekend Show NG. You can also follow us on social media at Weekend Show NG on Facebook, Instagram, and Twitter. You can also follow me on Facebook, Instagram, and Twitter at Andy Madaki. Do have a blessed week and do take care of yourselves. That's all for today. Thank you.